And welcome back, folks. Counselor, you ready to bring in the jury?
No, I do have an issue I need to raise with the court.
Okay, well then have a seat, folks. Thank you. Go ahead, Mr.
Thank you, Your Honor. Your Honor, I make this request reluctantly, but I think it's an important request for the court to consider. I had it brought to my attention by a number of people following the conclusion of the state's comments just before noon in closing argument that Ms. Lister is making very audible comments that are audible to people sitting at counsel's table. I, of course, did not hear them because I'm focused on the jury. Apparently very disparaging comments about me. I don't mind that personally, but I'm very, very concerned about the ability to impact these jurors. I know Ms. O'Connor is about to stand up and give a closing argument. I know Ms. Lister has some fanciful belief that she is a counsel for Michele Anderson, which is not true. And I am concerned that whatever Ms. O'Connor chooses to say will be impacted negatively by Ms. Lister's inability to control herself. She says she has interruptive disorder. She apparently cannot control it. She has been warned before that there is a history of this. And I'm also concerned that she's having an animated conversation immediately in front of that jury room door where Mr. Eo is now standing. Those doors are not that thick, and I am very concerned about the possibility of misconduct. And in this trial, I'm asking that you have asked Ms. Lister to please leave the court.
Okay. Ms. Sorensen, you want to weigh in on this? I'll be candid with you. I can't hear it from up here. That doesn't mean it's not occurring, but I just frankly can't hear it. So, Mr. Sorensen?
Your Honor, I don't think we really have a position or anything to add to Mr. O'Toole's request.
Okay.
I can, factually speaking, I haven't heard anything. I don't doubt that other people have, but I haven't heard it sitting here.
And I will tell the court, it's not just simply family members of the Mantle or Anderson family. It's people who have no dog in this fight at all. There's an esteemed member of the defense bar, elderly member of the defense bar, who approached me and indicated to me that he had heard comments. There are others in the audience who have also heard comments. I know my co-counsel, I believe, heard that there was definitely comments being made, but she couldn't discern that the others could, though, in the audience, and that is really of concern. Not only because it may impact both parties' right to a fair trial, and Ms. O'Connor's closing argument, but the position that Ms. Lister takes right next to the jury room door as the jurors come and go is a real concern that she will mutter something because, as she says, she has interruptive disorder that apparently she cannot control. And I'm very concerned about both parties' right to a fair trial.
I certainly am too. And Mr. Sorensen, you said you had nothing else to say about this?
Right, we're in a position where we need to defer to the court simply because we don't have enough facts to take a position on the issue.
And to be quite candid about it, my concern is given the current penchant for the Supreme Court to reverse anything, when the court does any action that impedes the public's right to attend proceedings, it makes me a bit timid about what I need to do in order to make an adequate record for that purpose under Bone Club and the rest of the case law. Frankly, if I had my way about it, we'd be having a hearing and I'd be taking testimony from folks in the gallery that have heard what's been said and so forth, so I can make an adequate record, because I suspect Ms. Lister will tell me that none of this is true.
I'm happy to have one of the persons who is a member of the bar advise the court of what he heard, and he's one of the first persons to advise me immediately after we broke for the lunch hour. That would help the court.
I may not need that. Ms. Lister is standing and apparently wants to say something. So, Ms. Lister, go ahead.
Yes, Your Honor. Thank you for your time. And I do not appreciate him slandering me as far as I believe I'm Michele Anderson's defense lawyer. I'm here for protecting appellate issues only, as I've told you. We've established that. His outrageous claims are incorrect. The person who was there, this person was sitting right in front of me and overheard something that I whispered 4 words to somebody else that didn't have any, thing about something about the case. It was maybe a dig on the prosecutor in his behavior of how over the top his performance was. And it wasn't to be heard by somebody else. We've corrected the issue that the prior listening device was very staticky to where it was turned up so much, and often I have to remove things from my ear so I'm not getting a headache. Some of them are tighter, some are not. I think the problem is solved. If I owe an apology to anybody, I apologize to the family, because that's who I would apologize to. I've done nothing that's not different than anybody whispering in court. That's happened a time. People coming in and out, students and law students. There's nothing that has given any information, indication, bias of anything in the trial. And I think that's where your line is, that what you're supposed to protect. You know, as we know, there's a right to access to courts with TV and her not seeing her, you know, discovery, lots of access to court things. And I think you are correct in reserving the fact of throwing me out at the inclination that one person stood up after you were in chambers and said or repeated what he thought he said or had heard from him out of my mouth that everyone else heard, so then it multiplied from there. But other than that, one person that I know of heard it, because these benches are too close in proximity. That's why everybody squishes in between, but it was meant for the person next to me. And I'm not at the jury door, and this prosecuting person is always standing guard of the jury door. There's media between me. There's the static of media possibly as well. So I think the issue is resolved, and I appreciate you reserving that, because I do believe it would be an appellate issue, as we've already stated and put on the record. Just, I would like no more slanders from Mr. O'Toole, and the family deserves to finish the trial. Michelle deserves to finish the trial. And I think this is part of the circus making that Mr. O'Toole is involved with Mr. Sanders as well, from what I've seen posted. Thank you, Your Honor.
I will advise the court that I've been advised by Detective Tompkins that Ms. Lister's comments were picked up and recorded by the media on the TV camera. So the jury.
And do we have an indication of how many words, how many sentences, duration of time, anything like that?
I do not. And as the court can imagine, I know the court is as concerned, if not more so than anybody else in this room, with respect to being able to finish this trial. You know, I totally understand, and I don't mean to make the court's life more difficult. I really don't. But
no, you're not making my life difficult. Frankly, the appellate courts have made my life difficult because they turn this into field day for anybody who wants to come and go. If I had my way, people wouldn't be treating this like they were at the movies and having little conversations in the background. They'd come in here and they'd sit down and they'd shut up. But that's not what happens nowadays. And it makes it very difficult to control. People come and go. I was given jury instructions earlier this morning, and some gentleman was climbing over people in the back row loud enough to cause me to interrupt him in the instructions. It's making it impossible to do this job the way I think we ought to do it. And right now, my best solution to the problem, if I'm going to address it, would be to take testimony, make a sufficient record. And then I think what I would hear from Ms. Lister is she needs an ADA accommodation, which I would then have to go through that entire set of protocols. And then I'd probably have to find her an alternative viewing space and get a Skype set up so that she could watch it remotely. Otherwise, I run afoul of ADA accommodations. It gets worse and worse the further you go down this path. And I hope everybody in this courtroom understands that. And in the meantime, we're trying to try in a fair, efficient, appellantly correct way a 6-count homicide case while dealing with all of this other static noise.
Your Honor, I have a solution. I will step outside and use my hearing device if that will suffice for you in the event that I have done nothing wrong. And that's, I'm not a person to drag out the appellate ADA. I asked for full accommodations and you gave me half, as the record you have shown. I would gladly step outside. I'm not going to take your time. But again, I reiterate this to the media circus of him being blaspheming. He's more worried about his character and why he couldn't get Paul Sanders to have that initial feed when the media wasn't here. And that's what that is stemming from. So I will gladly step outside if it appeases the court. You will not have any more problems that are brought up from somebody who is sitting right next to me, not everybody else, as it's been sputtered over the break.
Okay.
And I do not ever talk to jurors. I wouldn't do something like that until conviction or appellate process or whatever happens after that. I have no intentions of that at this time.
Okay,
so thank you.
Ms. Lister, can you hear?
I should be able
from
to.
the
I
hallway?
have a new device, and that's one of the problems that it was. I've solved it with the help of Kenya. I actually went and solved it myself with court administration and interpreter services. We're all fine. Thank you, Your Honor.
Okay, so Ms. Lister, if you, I want to make it clear for the record, you're voluntarily making this action to move into the hallway to avoid further complications.
For closing
Right,
argument,
that?
for closing arguments, if there's anything on the record as far as addressing something after that, when the media is out there and gone or on a break, then I may re-enter the courtroom at my own leisure, if that's okay with the court as well, for anything that goes on as far as motions where the jury's not present.
I just want to get through closing arguments this afternoon.
No problem.
The jury needs to get this case for deliberation.
You and I are on the same page. Thank you.
Okay.
Judge,
Now,
I want to apologize for this morning, since you brought...
I shouldn't even know who it was, sir. Was it you?
Yeah, no,
Okay.
I apologize.
I appreciate that. I appreciate your apology, sir, but it's the problem that's inherent with people coming and going. If I had my way, we'd start the proceeding, close the door, and if anybody wasn't here yet, too bad. And if everybody comes in, they stay until we're done. But I don't have that kind of power and control anymore, thanks to my friends who have appellate courts who don't have these problems. So with that, I think we're ready now for the jury to come in. As usual. And Ms. O'Connor, you're good to go? Yes?
I'm sorry.
Okay. And I'll let the jury know about the typo on page 28 of the instructions.
Please rise for the jury.
Welcome back. In a moment,
May it please the court, counsel, Ms. Anderson, members of the jury. Unstable, paranoid, spoiled brat. These are some terms that we've heard used to describe Michele Anderson by some who knew her best. Her sister, Mary Victoria Anderson, and Judy's best friend, Linda Teeley. We often hear that a trial is like a story. There's plots, there's character, there's a crisis, and there's resolution. But sometimes with a trial, we do not have all of the pieces, so we work with what we have. This is not, as the prosecution would have you believe, a crime about money and greed. Remember, Michele Anderson and Joseph McEnroe, between them, had almost $20,000 in the bank. That's more than enough money to get to Canada, more than enough money to get to Las Vegas. So what do we know about Michele Anderson's state of mind at the time? We heard from her sister, Mary Victoria Anderson. She described Michele as a spoiled brat, but she also described Michele as someone who lived in her own little world. That starting as early as when she lived in the Spring Glen trailer park, she began hiding out in her trailer. She hung black curtains in her windows. She started to withdraw from her family, from her friends. She couldn't even hold down a job, to the point that she hadn't been working for at least a year preceding this incident. Mary said that Michele told her people were out to get her. She said that Michele would freak out or flip out and talk about, I just want to kill them, just want to kill Dad. She'd been saying these things for a very long time. But her family did not think that she was serious. They knew something was wrong. Judy just wanted to protect Michele. She loved Michele. She thought if Michele moved back to the family property, she could protect her. She could help her. We also heard from Linda Teeley, Judy's best friend, who told her that Michele was unstable and she was worried about her. We heard from Michele herself through her confessions to Detective Tompkins, Peters, and Cleary that she has suffered from depression, that she has suffered from anxiety, that she had been given medication in the past. And this all seemed to start several years ago, around the time she had an ear infection. You can also look at the condition of the trailer where Michele and Joe were living. It tells us something about her state of mind. You heard from Sergeant Gray, Deputy Orender, Deputy Walker, Detective Tompkins. That trailer was filthy. There were clothes and garbage strewn everywhere. It was cold. It was damp. There was an odor. And you have the videotape in Exhibit 3, and you can see for yourselves the condition that she was living in. It shows the condition of a person with a very disturbed state of mind. Michele's truck is similarly littered with trash, paperwork, cat litter. Ladies and gentlemen, Michele is, even now, presumed innocent. That presumption of innocence carries with you even when you go back in that jury room and you begin considering the evidence presented. And it is only overcome when the state has met its burden of proof beyond a reasonable doubt. And that burden must be applied to every element of each of the 6 crimes, to every aggravating factor, and to the enhancements. And what does it mean to have a reasonable doubt? And we talked about this in voir dire a little. And now you have the instruction from Judge Ramsdell on what the law tells us about reasonable doubt. A reasonable doubt is one for which a reason exists. It may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable juror after fully, fairly, and carefully considering all of the evidence presented. And ladies and gentlemen, as we review the evidence in this case, we see that there is not just one, but several reasons to doubt. The state has presented a lot of forensic evidence. We've heard testimony from the medical examiners, from the Washington State Patrol Crime Lab forensic scientists, from the trackers, from the crime scene reconstructionists. And this evidence is relevant, for the state must prove the elements of murder. But what the forensic science is unable to tell us is who is responsible. What is the state of mind of the person? The confession sheds light on Michele Anderson's state of mind at the time. She admits to you, through her confession, that she is responsible. But what she tells you about her reasons why sheds light on issues of premeditation and intent. Michele said her plan was merely to confront her parents, to try to convince them to take her side on this argument that she had with her brother. She says she carried her gun for protection in case Scott attacked her. The detective said, well, Scott wasn't there in the initial scene, but she was afraid and she knew he was coming. She also says, I didn't want to hurt anyone. I freaked out. And it's relevant, too, that when she fires at Wayne, she misses. Michele said in her confession her plan was to get the money Scott owed her and just leave. But then she and Scott argued. She thought Scott was going to hurt her. She said, I panicked. But she did so in an argument, in the context of a struggle. And you'll have this statement in evidence, and the prosecutor is drawing some highlights to some things that Michele said, but there are also the other things that you need to consider with regard to what Michele actually said. Page 41, she talks about how she panicked. Page 42, she talked about how she thought Scott was going to hurt her, that he hates me. Page 43, he kept coming. I didn't want to. I thought he would stop when I pointed the gun. Page 65, I didn't want to shoot my parents. Throughout her confession, she talks about what her state of mind was and what she wanted to do and what she didn't want to do. You can also consider her demeanor, which was testified to and which you can hear when you listen to the tape. Michele is timid. Her voice starts out normal and trails off. She becomes increasingly apologetic. She's rambling. She's crying. Michele also made statements to Detective Cleary about her state of mind and what was going through her mind. She was upset with her brother because he owed her a lot of money. She was upset with her parents because they took Scott's side. They told her she's just making it all up. They didn't believe her. Her mother slandered her. Her father was abusive. Scott was abusive. She went crazy. She suffers from depression and anxiety. The fact that she goes back and forth throughout her confession, saying it's all my fault, to it's my fault for these things and Joe's fault for these things, that's a reason to doubt, ladies and gentlemen, because she's all over the map. She talks about how she's tired of everyone stepping on me. I thought they were all against me. I got paranoid. I went crazy. Pages 95 and 96, 51 to 52, 60. Throughout her confession, she talks about these things. Yes, she talks about money, but money isn't the issue here. Her crazy, delusional state of mind is what is propelling her thought processes. Similarly, the post-crime activities show that this was not a well-thought-out, premeditated plan. They go up north to Monroe. They get gas. They go east to Gold Bar, thinking they're heading north, I suppose. They're lost. They buy a map. They turn around. They go back to I-5. They throw the guns in the river, and they go home. They don't go up to Canada. They've got a map now. They know how to get there. Michele says, we went back and forth. Throughout these 2 days, she and Joe are going back and forth. Turn ourselves in. Run away. Fear. But Michele says she can't live with herself, and ultimately she comes back. They do drive down to Las Vegas and say they're going to get married. And I would submit to you this is not an alibi. She tells Detective Tompkins they really did want to get married before they came back and faced the consequences. They wanted to have that last activity together. But the bottom line is, they come back. And what do we know about that trip to Counsel that also sheds some light on this activity? If you're planning a long road trip, you're going to check your tires, you're going to check your gas, you're going to check your check engine light, you're going to make sure the car is ready and in good condition. They didn't do any of those things. They didn't even know where the jack was. They didn't even know the spare tire had a lock on it, let alone have the key to that lock. And we heard from Randy Knapp, who said, it's kind of weird. They don't even have any luggage in their car. If this was a well-planned out trip to hide, to flee, to avoid responsibility, it sure isn't looking very well planned out. And Mr. O'Toole mentioned something that I think Mrs. Knapp said about Michele's change with regard to once she knew the State Patrol was on the way. Well, if you look at her original statement, she said that Michele was mellow, that she had called the State Patrol first and then she called Michele, and there was no change in her demeanor at that time. And yes, indeed, they did turn around and come back and face the consequences. Now, Michele, as Mr. O'Toole points out to you, took a little while before she confessed. She talked to Detective Tompkins for some time before she broke down. And I asked Detective Tompkins, was she still trying to exonerate Joseph McEnroe? And the answer is yes. Michele wants to accept responsibility, but at the same time she wants to protect Joe. And that hasn't changed. You can also consider what they did not do. Again, if this was a premeditated plan to just get the money and flee to Canada or flee to Las Vegas, they didn't. They didn't go through the house and find all the money. They did take $40 from Judy's purse, but there was a lot more money in that house. There was a lot of guns in that house. There was a lot of property in that house. This was not about money. Again, they didn't pack. And when she begins to talk, Michele talks, and she admits her responsibility. And she tries to take responsibility for everything, and then when confronted with Detective Tompkins, well, Joe's telling us something different, she begins to break it down. The other thing you can see throughout her confession is that Michele has remorse for her activities here. She's crying. She talks about how she loved her family. She didn't want to do it. She confesses before Joe confesses. She says she knew it was wrong. She needed to turn herself in. She and Joe went back and forth, but she could not live with herself, and she returned. Her mood swings, timid, sobbing, normal, back and forth. But she says at pages 73, 77, 79, 92, and 97 that she came back to turn herself in. So now you can take this evidence of her state of mind and apply it to the to convict instructions as you go through. First of all, there's instruction number 8, which tells you that a separate crime is charged in each count. That means you deliberate on each count separately. So if you find her guilty on one count, that doesn't mean she's automatically guilty on the others. You look at the evidence as applied to each count separately. And there's also the instruction on accomplice liability, instruction number 9. And the state relies on this language about solicit, command, encourage, request another to commit a crime. But the instruction also tells you that more than mere presence and knowledge of the criminal activity of another must be shown. And ladies and gentlemen, we don't have evidence of what Joseph McEnroe's state of mind was. To find Michele guilty as an accomplice to the crime he committed, you have to know what his state of mind was, and we don't have that evidence. So going through, in order to convict Michele Anderson on count 1 with regard to premeditation, she fired her gun at Wayne Anderson and missed. That shows a hesitation on her part, an inability to go through with what she wanted or thought she was going to do. That negates all the premeditation that might be leading up to that moment in time. She withdraws. She fires and misses. She's not guilty of first-degree murder with regard to Wayne Anderson. Similarly with count 2, Judy Anderson. She doesn't fire and kill her mother. Joseph does that. And ladies and gentlemen, this wasn't some spread out activity. This was bang, 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 bang. As Dr. Harif told us, Judy Anderson lost consciousness immediately. That first shot that hit her was devastating. So we don't have evidence of premeditation on that count either. Count 3, Scott Anderson. Michele admits to shooting her brother. The evidence shows that she shot her brother. But again, premeditation. She says in her confession, I just wanted to get my money and leave. I didn't want to hurt him. I didn't want to hurt anybody. Evidence of premeditation is not there as to Scott Anderson. She did intend and did indeed kill him, so she is guilty of second-degree murder as to Scott Anderson. Similarly with Erica Anderson, there is a lack of premeditation. She does admit to firing the shots with the .357 that hit Erica. But there is discussion in her confession about Erica reaching for the phone and wanting to stop that. She is guilty of second-degree murder with regard to Erica Anderson. With regard to count 5, Olivia Anderson, Joseph McEnroe shot Olivia in the head with a 9mm. Ross Gardner testified that the wound to Olivia's abdomen with the .357 was quite probably she was caught in the crossfire aimed at her parents. That was not a premeditated shot to Olivia. And Joseph McEnroe is responsible for shooting and killing Nathan Anderson. Prosecutor talks about how the forensic evidence supports the prosecutor talks about how Michele lied throughout her confession, but she told the truth throughout her confession. And the forensics supports her confession that she fired at Wayne and missed, that Joe killed her mother, that she killed Scott, that they together killed Erica, and that Joe killed the children. The forensic evidence supports that. But again, with regard to being an accomplice to Joseph McEnroe, there is no evidence of what his intent was, what his state of mind was, and whether once Michele hesitated, had he just said no, it could have stopped there. I'd like to take a minute to talk about the aggravating factors. Instruction number 29 talks about the aggravator for counts 1 through 6. That there was more than one person and the murders were part of a common scheme or plan. Again, we don't know what the plan was. The evidence that we have of a plan was to just get her parents to agree with her and back her up in this dispute over Scott. Her back and all would be well. Also, that aggravator only applies if you find her guilty of first-degree murder. It does not apply if you find her guilty of second-degree murder. And that aggravator requires that Miss Anderson was a major participant in the acts causing death. If you have a reasonable doubt, then you have to answer no to the aggravating factor. Similarly, with instruction number 30 and the second aggravating factor that applies to counts, 4, 5, and 6, that the murders were committed to conceal the commission of a crime or to protect or conceal the identity of the person committing the crime. As Ross Gardner told us, this was a dynamic scene. It all happened very, very quickly. And again, you have to find that she's guilty of first-degree premeditated murder in order to find this aggravating factor. And with regard to Michele's intent with whether or not she wanted to kill the children or she told Joe to kill the children, lost my place, if you can bear with me for just a moment. Page 74. Who told Joe to shoot the kids? I did. Are you sure? You said Joe shoot the kids? That doesn't make any sense. And it doesn't make any sense. Somebody's not going to shoot a child because somebody else told them to do so. She also talks about that she didn't want to kill the children. But it was Joseph McEnroe who killed the children. If you look at Michele Anderson's state of mind, at best, you find her guilty of second-degree murder on Wayne Anderson. Second-degree murder as to Scott and Erica. Not guilty as to her mother. Not guilty as to the children. Or second-degree at best. There are several other instructions in this packet that will guide you as you begin your deliberation process. That very lengthy instruction, number 1, at the very beginning. On page 2 at the top, it says, in order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of the evidence, whether or not that party introduced it. That instruction continues that you have nothing whatever to do with punishment except insofar as it makes you careful. In order to convict somebody of these most serious crimes, you must carefully consider all of the evidence presented. And do not allow sympathy or prejudice to guide you. That's an inhumane request that we place on you as jurors. Set your humanity aside and decide this case on the facts. And we recognize that that is a tremendous burden to put on you. But I do ask you to, as best as your abilities, set it aside and consider the evidence as it has been presented to you. And in weighing that evidence, instruction number 27 is also a very important guide to you as you consider this case. It talks about the deliberation process, and when you go back in there and you start looking at your notes and you start talking to one another about this evidence and what it shows, you're going to have some disagreements, and you're going to remember things differently. And while you bounce those ideas and talk about them, do not give up what you believe is right just for the sake of reaching a verdict. You should not change your honest belief as to the weight or the effect of the evidence solely because of the opinions of your fellow jurors. Instruction number 28 is likewise a very lengthy instruction. But there's language at the very end of it. Since this is a criminal case, all 12 of you must agree in order for you to return a verdict. That means that as each charge, you have to be unanimous that the state has met its burden of proof, aggravator, and the enhancements. So if there's disagreement, if some think first degree and some think second degree, then the law tells you you have to go with the second degree. And if you cannot decide on guilt at all, then you have to enter not guilty, even though some of you might think she is. You have to all unanimously agree beyond a reasonable doubt. Mr. O'Toole likes to talk about some of the stories that he's read. I, too, am reminded of a story when I think about this case. There is a book written, turned into a movie, A Beautiful Mind. Many of you have probably seen it or read it or both. And that story tells about the descent into madness. And we recognize that the mind is a complicated thing. We do not always know what motivates a person. We do not know why bad, horrible things happen to good people. But I ask you, in holding Michele Anderson accountable, that you hold her accountable only for those acts proved, for those states of mind proved to you beyond a reasonable doubt. I ask you to fairly, fully, carefully consider all of the evidence presented and to find Michele Anderson not guilty on 6 counts of aggravated first-degree murder. Thank you for your time.
Thank you, Mr. Brown. And ladies and gentlemen, because the state does indeed bear the burden of proof in this matter, the state is afforded the opportunity for a brief rebuttal. Mr. O'Toole, are you ready to go?
I am, Your Honor. Thank you.
Go right ahead, sir.
Good afternoon. I'm going to speak to you just for a couple of minutes, and then I will sit down, and this case will be yours. You'll have all the evidence. You'll have the recollection of the testimony of the witnesses. You'll have the opportunity to deliberate amongst yourselves for the first time. So let me begin maybe at that point and discuss Ms. O'Connor's comment about not surrendering your true and valid views with respect to reaching a verdict in this case. And she's right. If you actually believe this defendant, the state has not met its burden of proof, you should not surrender that. But recall, one of the things that Ms. O'Connor did not mention was jury instruction number 20 says, as jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. There is a duty to talk, to deliberate, and to come to the right decision. And I am confident that you will do that as you deliberate this case. Ms. O'Connor says, well, it seems that people thought that Michele Anderson was different or was odd, or her sister said that she acted bizarrely sometimes, and that somehow that reflects her mental state on Christmas Eve of 2007. Let me mention what Michele Anderson actually said about her supposed mental state, and whether or not she had any history of issues and problems. Ms. O'Connor mentioned it briefly. I will mention it a little bit more thoroughly here. And her answer is, I should have. And this is at page 87 of 112. So this is now somebody who's been talking to Detective Tompkins for an hour and a half or so as they go down this path, and he tries to explore what actually happened and why. So Detective Tompkins says, okay, but have you? And the defendant says, I have depression problems. And he says, but have you? She says, no. How do you know you have depression problems? And the defendant says, well, because a doctor told me once I did. I almost lost my hearing in 98 or 99. This is 10 years before the murders. Because of an ear infection, and they gave me antidepressants to cope and help the ears heal faster. Now, we have no idea whether any of that is true, but let's assume it is true. That says nothing about her state of mind on Christmas Eve of 2007. So Detective Tompkins, always the good detective, says, well, what doctor was that? She says, trying to remember his name. I don't remember his name, but he worked in Issaquah. That should tell you the seriousness with which Ms. Anderson herself gave that view. Okay, has anybody ever told you? And she says, my family said I'm depressed all the time, and that, but they went overboard with it. They said that everything I feel is not valid. Is that the basis for her self-diagnosis of depression, because her family doesn't cater to her every need? You heard her sister, Mary Victoria. She said she was a spoiled little girl who was doted on by her father. And all of a sudden, she's not the center of attention of her brother's life anymore, and someone's going to pay for that. So Detective Tompkins says, has a doctor ever diagnosed you as being paranoid or schizophrenic? No, says Michele Anderson. Or bipolar? No. I took tests to make sure that I wasn't any of those. I just have depression. That says nothing at all. In any way does that undercut the premeditation from her actions, from the physical evidence, from the forensic evidence, and what she said, the overwhelming evidence of premeditation and what she did on Christmas Eve. Ms. O'Connor mentions the conversation about who told Joseph McEnroe to shoot the children. Here's how the exchange actually went. Detective Peters, who told Joe to shoot the kids? Michele Anderson, I did. Detective Peters, are you sure you said Joe shoot the kids? That doesn't make any sense. Ms. O'Connor stopped there. Here's Michele Anderson's answer to that. The detective says that doesn't make any sense. That's not Michele Anderson saying it. Detective Peters says, are you sure that doesn't make any sense? And Michele Anderson gives a very rational reason. Quote, I said we have to kill everybody because I was afraid. So it does make sense. And if you read the complete quote in context, it speaks volumes of Michele Anderson's state of mind. Ms. O'Connor says, well, you know, it looked like Michele Anderson had $9,000 plus in the bank, and Joseph McEnroe had $12,000 in the bank, and So they could have gone to Canada, they could have gone to Las Vegas. Well, they also could have started paying rent. They also could have started paying for their insurance. But to suggest that people who might have $9 or $12 or $21,000 in the bank aren't driven or motivated by money, I think is to ignore the reality that some people value money a whole lot more than others. And if Michele Anderson and Joseph McEnroe had that amount in the bank, and there's no reason to think that they didn't, why was she so upset about paying rent? This is a woman who was so self-centered, so narcissistic, so much the spoiled brat, that she got angry at her parents. How many times did she mention the word rent in her statement? She wasn't going to get thrown out in the street. That was a lie. She has $21,000 in the bank if you combine her resources with Joseph McEnroe. How does that become a defense all of a sudden? I would suggest to you that it does not. Ms. O'Connor says, well, we don't know anything about Joseph McEnroe's state of mind. We don't need to know anything about Joseph McEnroe's state of mind. We don't. We're focused on whether the state has proven beyond a reasonable doubt the elements of the crimes of murder in the first degree. And if you look at the defendant's actions, her words, the objective, extrinsic, and scientific evidence, it is beyond any shadow of a doubt that she premeditated the murder of these 6 human beings. But guess what? We do know something about Joseph McEnroe's state of mind. Because we know from the defendant saying it over and over again, she was to kill everybody. McEnroe was the backup. McEnroe was to protect her. And guess what? He did his job. We know about his state of mind because when her gun jammed, when she fired on her father and missed, and how trying to shoot your father in the head and missing becomes hesitation, becomes all of a sudden I don't premeditate or intend the consequences of my act. How does being a bad shot translate into I'm not a murderer? Are you kidding me? But we do know Joseph McEnroe's state of mind because when Michele Anderson's gun jammed, they were in trouble. She had just shot and tried to kill her father. My guess is he didn't take it that well. And Joseph McEnroe came out of that back bedroom and did as he was instructed by Michele Anderson and pulled out that .357, pointed at Wayne Anderson's head and pulled the trigger and killed him. That's murder in the first degree. And that is accomplice liability. At a minimum, Michele Anderson is an accomplice. But we know for a fact, of course, that she was a principal. We also know Joseph McEnroe's state of mind because he did a pretty thorough job of killing Judy. Remember, this would have been done by Michele Anderson if her gun hadn't jammed. And Judy's reaction to the sight of her husband being shot in the head and landing on that dining room floor was to flee into the kitchen. And the fact that we know Joseph McEnroe pursued her, fired that first round that missed her. Ms. O'Connor says, well, when Judy was hit in the neck, she was unconscious. Your recollection is much better than mine with respect to the testimony. But I believe what Dr. Harris said was she was conscious. She was not dead. And that is a huge difference. Here is a woman who's been shot at and missed. Imagine what's going through her mind. Joseph McEnroe, at the behest of Michele Anderson, advances on her, shoots her in the neck, and she goes down. And she is paralyzed, literally, and frozen in fear and terror for however long it was they gave her until they put a bullet in her head. That speaks volumes about Joseph McEnroe's state of mind as well. And Ms. O'Connor says, well, Michele Anderson talked about that what she did, what she wanted to do, and what she didn't want to do. Folks, she minimizes in some places. She embellishes in others. She out and out lies in other places. She would not be the first person suspected of murder to maybe make up a story, maybe to embellish facts or to minimize her own involvement, to try to do those things that make her seem not as responsible. She has had 2 days to think about this. These murders occurred on the afternoon of December 24th, 2007. She's talking to the detectives just before noon on December 26th, 2007. Ms. O'Connor says, well, money is not the issue. Well, if it's not the issue, why would you mention it 35 times in about 70 pages of transcript? Because after page 39, between page 39 and 112, Michele Anderson talks about money. Michele Anderson talks about rent. Michele Anderson talks about having to pay insurance. Michele Anderson talks about her anger at her brother. Michele Anderson talks about her anger about that car. 35 times in 70 pages of transcript. But you say that money wasn't an issue? That's just not the facts. Ms. O'Connor says, well, they didn't go through the house and take things. They could have taken things. Well, they did take, of course, they did steal money from a dead woman's wallet, and that dead woman would be her mother, Judy Anderson. They did try to find Wayne's wallet. We forgot to mention that. And Michele Anderson said, but they couldn't find it. So they did try to take things. But let me suggest this to you. Why would they need to go around and take things out of the house? Michele Anderson's about to own that house, because the people who owned it are her parents, and they're dead, and her brother is dead, and if her sister had been there, she would be dead, and the only person who would own that house and that property would be Michele Anderson. She didn't have to go around and take what was almost already hers. And Ms. O'Connor says, well, you know, when she first arrived at the property, she was timid, she was tentative when she was talking to Detective Tompkins. Well, remember, she shows up at the property. These detectives and the officer, Deputy Chafee, who met her, they don't know she's a murderer. They don't know she just murdered 6 members of her family, but she does. It might explain her hesitation, her reluctance, her timidity, because she doesn't know what they know. She doesn't know if she's a suspect or not. That might explain exactly why she is so cautious when she first is talking to Deputy Chafee, and he says she looked a little bit perturbed and timid. Ms. O'Connor says that, well, really, Michele Anderson wasn't involved, I guess, in the murders of Olivia and Nathan because Joseph McEnroe did that. Joseph McEnroe did that because the defendant told him to do that. We just went through that. Who told Joe to shoot the kids? I did. Why? Because they all needed to die. I was scared. The defendant is the person who told Joseph McEnroe. That's, at a minimum, accomplice liability. And the only reason why Michele Anderson didn't shoot those 2 little kids in the head is because she was out of bullets. Her .357 had already fired 6 rounds. She had to reload. And Erica Anderson was going for the phone. And remember those words of Erica Anderson on the phone. Not the kids, no. Really? And Ms. O'Connor says, well, that second aggravating factor about the crimes in counts 4, 5, and 6 were aimed at killing witnesses either to the crime or to conceal the identity of the perpetrator. Can there be any doubt at all when the defendant herself says those 2 children were killed because they were witnesses? Can there be any doubt at all when Erica is the one adult in the room who apparently does not owe, in the defense mind, her money? Erica has to die because she just watched her husband get shot to death. And to say that Ross Gardner said all things happened rather quickly, it was a very dynamic situation, that's true. But it's a dynamic situation put in motion by Michele Anderson, who told Joseph McEnroe she was going to kill everybody and he was backup. And that was the plan. That was what was thought out, and that was what was discussed, and that's exactly what happened. Ms. O'Connor talks about a movie, A Beautiful Mind, and a descent into madness. Oh, there's no descent into madness here. We look at her actions, at her words, the objective evidence, the forensic testimony. There is no doubt in every conceivable way. From a woman who says she thought about the murders of her parents for 2 weeks before she did it, of her brother for 2 weeks, that she went up the hill with the intent to shoot them. She went up the hill with a gun that was fully loaded and wrapped in a sweatshirt. That's not a common, normal way people show up for Christmas dinner, I think. She went up there to kill them. And that's exactly what she did. Ms. O'Connor says, well, you know, you must focus on whether the state has established this case beyond a reasonable doubt. She's absolutely right.
She's absolutely right. But that is not an impossible task. It is a doubt that would exist in the mind of a reasonable person after fully, fairly, and carefully evaluating the evidence. For many people, I think they would like to think that reasonable doubt is kind of like the horizon. You can always see the horizon, but you can never reach the horizon. It never happens, and it doesn't really exist. You can see it, and somehow reasonable doubt is like that, but you can never actually arrive at that point where you're satisfied beyond a reasonable doubt. That is not what the law says. If you have an abiding belief in the truth of the charge, if based on the evidence and the testimony and the deliberations with your jurors, you are convinced of the truth of the charge, you're satisfied beyond a reasonable doubt. Ms. O'Connor talked about inconsistencies in the testimony. I think she talked about Kathy Knapp and all. Of course the witnesses are going to be inconsistent. It's been 8 years. It has been 8 years. And these are human beings who view evidence and view what happened at a time when they didn't really have notice that they were supposed to remember this stuff because it didn't mean anything to them. Somebody calls for a change of tire at 5:30 in the morning of December 26th. I don't know that anybody thinks, I got to remember exactly what happened because this is a mass murderer who just called me. I don't think Kathy Knapp knew that. I'm going to suggest something to you. Watch what happens when you guys go back to that jury room. Some of you took a lot of notes. Some of you didn't take as many notes as others. And some of you sort of took some notes and decided not to take notes. And you're going to get back there and maybe talk about some factual issue, and somebody over here is going to say, here's what I remember, X, Y, Z. Someone here, or here's going to say, I don't remember that at all. And someone here is going to say, well, I remember that, but not quite that way. And you guys have been here focused on this trial for 5 weeks, but you're inconsistent. Does that mean somehow you're misleading each other? Or somehow you're lying? No, it means you're human beings who view things from a different vantage point and a different perspective. It doesn't mean someone is lying or purposely trying to mislead. Finally, Ms. O'Connor says, well, Michele Anderson came back to confess. Really? Is that why she came back? Because that's not what she said. And if you look at her words, or listen to her words, and you look at her actions, there is no way that Michele Anderson came back to confess. She admitted to the police that she and McEnroe planned their alibi in advance. They had no intention of turning themselves in. She lied from the get-go, from when she met Scott Tompkins to when she got into his car, to when he turned on the recorder, to when they went on the ride-along and tried to find the weapons. She told him that they had made up the story of Las Vegas and they were going to go get married. At page 92, did you guys, this is Detective Tompkins, did you guys talk about as you're walking down the driveway, that was the story you were going to tell the police that you were going to Vegas? No, we wanted to go to Vegas and get married anyway. Okay, what do you suppose Joe is saying to the police right now? That we want to get married. Okay, so that's the story you guys agreed on? Yeah, but we want to get married anyway. And then at page 97, so Joe's been talking to some detectives down the roadway here, okay? Is there any reason why he would have a different version of events than you? What is that reason? Answer, we talked about covering stuff up. Covering what? We went back and forth on whether or not we're going to confess, and he was covering it up, and he's not saying the same thing as me. The detective says, I asked you before about if you guys had an alibi in place. What was the alibi? What did you have a discussion about? She said, we were going to just say that and just not say anything else. They were going to tell the police that they were nowhere near the property at Christmas, just as Michele Anderson said, that they were leaving, they had left in the afternoon of Christmas Eve to go to Las Vegas to get married and not say anything else. And they were going to come back and act as if nothing had happened at all. The better explanation as to why they came back, I would suggest to you, is because they came back to stumble on a murder scene. It's been 2 days. There's nothing in the press. They come back to their residence, to their home, and they go up that hill, and what do they discover? 6 dead bodies. If they were going to call the police, it was to report a murder. And guess who the survivor is? Michele Anderson. That, I would suggest to you, is a much more plausible plan, because that explains why you fill your truck up with gas at 10:25. That's why I explained 35 minutes before you go back to the property. That explains why you make a car payment at 10:26, 35 minutes before you return to the property. That explains why you lie to the police for almost an hour. Why would you lie for an hour if your intention was to come back and confess? That doesn't make any sense. But perhaps this is most important. If you're returning to confess to the police, why do you drive home? Why don't you drive to the police station and confess? The truth of the matter is, when they turned in that driveway on December 26, 2007, they had no idea the police were going to be there. Michele Anderson did not finally confess. It fits and starts because she was trying to be honest. She confessed because she was caught in lie after lie after lie. Michele Anderson is guilty of 6 counts of murder in the first degree with 2 aggravating factors. And I would ask you to find her guilty as charged. Thank you very much.
All right, ladies and gentlemen, in a moment I'm going to excuse at least some of you to commence your deliberations. But before I do that, I have to select the 2 alternates. And if past experience is any measure, either those 2 people will be extremely relieved or incredibly disappointed. And I don't know which side of the fence the 2 of you are going to fall on. But I apologize in advance for whatever might happen. So, okay. The alternates are going to be juror number 7, Mangle, is that right? Thank you. And juror number 8, Mr. Trump. Over there? Okay. You moved on me, I think, a little bit. Okay. So you're the 2 alternates in this case. So in the batter's box in case I have to reach back in and pull you guys into the deliberation and start the deliberations anew. So if you could please continue to abide by those admonitions for the time being, that would be great. Once a verdict is reached, you'll obviously be relieved of all those restrictions, and you can talk to anybody you want and so forth. And usually we have the 4-person contact you to give you that news so that you can ask that particular person what might have happened in deliberations and so forth. But in the meantime, if you could continue to remain pure for all intents and purposes, that would be great. And again, thank you so much for your service. When I excuse you to the jury room, Kenya will collect your notepads and so forth, and we'll keep them in safekeeping for you in case we need to call you back for deliberations, okay? And again, thank you so much for your service. I hope you're not too disappointed. I'd rather think that you would prefer to be relieved of this duty, so I hope that's the case. So thank you again for your service. As for the rest of you, you're going to be getting your deliberation shortly. A couple of rules I need to tell you right now. First off, you get to take your notepads and those jury instructions and everything back with you to use as you see fit, okay? All deliberations have to occur in the confines of the jury room. So although some of you may go to lunch together and things like that, you need to conduct all your deliberations back there with all of you present, okay? That also means that if some of you show up early tomorrow morning and you want to start talking about the case before all 12 of you are assembled, again, resist the temptation to do that. All 12 of you need to be together for the entire deliberative process, and it needs to occur within the confines of the jury room back there. Also, I would ask that you turn off your cell phones and your electronic devices while you're in deliberation so it doesn't disturb that process. And I think that's all I have for you for the time being, so I'm going to excuse you to the jury room. Again, Kenya will release the 2 alternates momentarily. She might have some additional instructions for you as well. And for the rest of you, thank you again for your service and good luck with your deliberations, okay? Thank you. Frank, if I could ask the rest of you to be seated for a moment. Thank you. All right, Counsel, I don't think there's anything that we need to discuss before I release you for the afternoon.
Just a question, why is in regard the electronic exhibits that were admitted? So how you did put for them, and also
The electronic, if you're talking about the audio recordings and so forth,
CDs.
we will hang on to those audio recordings, instruct the jury that if they want to hear them again, to just let us know and we'll assemble everybody and put it in court.
You know, I apologize, Ms. Morales was
That's okay.
distracting. Did you say something about sending the exhibit list back?
No, no. She was asking about the electronic exhibits, the audio recordings and so forth.
Will you send a list back?
I wasn't planning on doing that. Is there a request to do that? Normally I don't.
I mean, I'd make a request if you're so inclined. I mean, I've had this on other cases, just that I think it helps the jurors find things and organize things, but
I think there's kind of a split opinion on that. Mr. Sorensen, what's your thoughts on it? If everyone agrees to send one back, then I suppose there's no problem in doing it, but that's not the normal protocol for me anyway.
I guess the problem I would have is if there's a list with things that are not admitted, that invites the jury to look at those and remind themselves that those are not admitted. So if the list goes back, I would ask it to be only of admitted exhibits, excluding.
we'd agree.
You don't have that?
No. Not without making it.
Yeah, it would have to be a separate obligation. Let me discuss that with the clerk and see if there's a way of getting it done. Because it's actually me imposing on the court clerk an obligation that I don't rightfully have an ability to impose. She actually works for the executive branch, believe it or not the judicial branch. It may seem odd to you, but that's my reality.
In the past, what we've done is whited out any boxes that have reference to exhibits that were not fully admitted, so they don't even get identified. There's just a blank there, and then use that. And we're happy to take that laboring work.
Any quarrel with doing it that way, Susan? Why don't you guys do this? If you want to put that together and it passes muster between the two of you, great. If for some reason there's some quarrel that requires my involvement, let me know. But it sounds like you're both in agreement as to what ought to go back and what shouldn't go back. Mr. Sorensen, you look a little concerned.
No.
Okay, I'm just checking. All right, so why don't you guys work that out and let me know if there's any reason for us to get involved. But since you're in agreement, I have no quarrel with doing that. Anything else that we need to talk about, Susan? I'm sorry?
My head sending back the handgun and the bullets, or separating the
Well, I think there's a general rule that everything goes, as long as that everything has been rendered safe, is my understanding.
I don't think there are any bullets that match the .357.
I don't believe so, so I think we're all good to go with that. Okay? Any other questions,
Your Honor?
Susan? Okay.
I have a question. Ms. Anderson is asking about where she'll be held. And I recall last year during the McEnroe trial, the court had a bit of time delay between when the verdict came back and to allow the family to get here.
Yeah.
Is that going to be the same practice again with this trial, or?
I think, and Mr. O'Toole, correct me if I'm wrong, I think we gave everybody about 40 minutes to get assembled for the verdict. Not necessarily every question that might come back from the jury, but for the verdict itself.
Your Honor, I would never contradict you. Well, I thought it was
Go ahead and try.
I thought it was 2 hours. Maybe I'm wrong, but
Was it 2 hours?
let me ask you. People might remember. I think it
Well,
was 2 hours.
if my bailiff says it was 2 hours, then I'm not going to argue with her. I might argue with you, but I'm not going to argue with her. Okay, so.
I guess our question is, could Ms. Anderson go back to jail now? as opposed to waiting here until 4.
I don't have any problem with that this afternoon, because I doubt very much we're going to get a jury question today that would require her to be transported back over. So for purposes of today, I think we can have her transported back over to the jail. Any other questions, folks?
Not from the state.
No, you're,
Okay, you sure? Okay.
for now.
All right, well, let me just say that I know this case has been tremendously stressful on everybody who's been involved in it, and I just want to commend counsel for the humane and professional way that you guys tried this case, because it could have been a lot harder on everybody, I'm quite confident. And I also want to commend the family members for the way they conducted themselves during this trial with a great deal of dignity, despite how tragic the circumstances are. So thank you all. The case is in the hands of the jury right now, and we'll let you know as soon as we hear something. Make sure Kenya has good contact numbers for all of you so she can get you fairly quickly, okay? And with that, if I could ask to have Ms. Anderson transported, please, and if the rest of you could remain seated for a while.
If we work for the executive branch,